dogs from the 5th Precinct. How are you guys?
Oh my God.
Some candy canes.
We have a sleep.
Hello, I'm Magistrate Zobel with the Denver County Court.
And I'm Magistrate Annis with the Denver County Court. We are here today to talk to you about suppression issues. Contact between law enforcement and citizens does not always result in candy canes and laughs. More often, the contact will result in an arrest, and for you, a motion from the defense to suppress the stop, the contact, evidence, statements, and observations made by law enforcement. A motion to suppress implicates the Fourth Amendment of the Constitution.
You may wonder how a suppression issue gets before the court. A defendant must file a motion to suppress evidence with the court and provide the motion to the district attorney. The motion filed by the defense should contain specifics about the contact and why the requested evidence, statements, or stop should be suppressed, because the defendant bears the initial burden to show that the contact, arrest, or search and seizure is unconstitutional. A fact-specific motion to suppress filed by the defendant is generally sufficient to meet the initial burden. The burden then shifts to the prosecution to show that the defendant's constitutional rights were not violated. The court should hold a hearing, take evidence, and make findings of facts and conclusions of evidence.
At the hearing, you will need to determine whether the initial contact between the citizen and law enforcement was constitutional. There are many ways that a citizen may find themselves in contact with a law enforcement officer, but the two most common ways are through a consensual encounter and when the citizen is driving and is directed by the officer to pull over. To decide whether the contact is a consensual encounter, the court should use the reasonable person standard, which is whether a reasonable person under the circumstances would believe he or she was free to leave and or to disregard the officer's request for information. Initial contact with law enforcement requires the officer have a reasonable, articulable suspicion for the contact. This occurs when a suspect is reasonably suspected of committing or has committed or is about to commit a crime. This standard is higher than that of a consensual encounter, but less than an arrest.
When driving, a reasonable articulable suspicion is generally found through bad driving or a minor traffic offense or infraction. The court should consider the totality of the circumstances in deciding whether the officer had a reasonable articulable suspicion in making the stop. Factors to consider include, but are not limited to, facts known to officer and any reasonable inferences, objective observations by the officers, and information obtained by fellow officers or consideration of the modes or patterns of certain kinds of people engaging in suspected criminal activity. It is important to remember that the officer's subjective motive for making the stop is not relevant to the analysis of whether a reasonable, articulable suspicion was present to justify the stop.
Following the initial contact of a driver, an investigatory stop may take place. The validity of the investigatory stop was first recognized by U.S. Supreme Court by Terry v. Ohio and adopted by the Colorado Supreme Court in Stone v. People. To determine whether an investigatory stop is constitutionally valid, the court must determine if there was a reasonable, articulable suspicion for the stop. The officer can ask basic questions of the suspect upon initial contact. These types of basic questions can include requesting the suspect provide their name, a form of identification, insurance, and an explanation for their behavior. The officer may also perform a check for warrants. There is a point when the investigatory stop becomes an arrest. Unfortunately, there is no magic formula to assist you in deciding if the investigatory stop has progressed to the level of an arrest. Typically, this happens when the questioning and length of detention of the driver are more than cursory. Once this takes place, then an arrest has occurred, and the arrest must be supported by probable cause.
If you rule that the initial stop or contact is unconstitutional, then the contact and all evidence acquired because of the unconstitutional stop must be suppressed. If the initial stop or contact is determined valid, the court may still find the subsequent detention or arrest was unconstitutional, and any evidence obtained after the unconstitutional detention or arrest must be suppressed. There is a doctrine intertwined with suppression issues that you should be familiar with. The fruit of the poisonous tree doctrine holds that any evidence obtained by law enforcement through unlawful or unconstitutional means is inadmissible for use by the prosecutor. All fruit of the original poisonous tree must be found inadmissible and suppressed. However, there are many recent cases which have reduced the rigidness of this doctrine. The recent U.S. Supreme Court case, Utah v. Strife, validated the attenuation doctrine and allowed for the admission of evidence obtained through unconstitutional police conduct when the evidence was sufficiently removed from the illegal conduct or the illegal conduct was interrupted by an intervening cause.
The next issue that you will often see, which also requires a hearing, is the defendant's request to have statements suppressed. The motion generally claims that the statement was the product of an illegal arrest, was obtained in violation of Miranda, or it was involuntary. Miranda is an advisement that must be given by law enforcement to a defendant when a defendant is in custody and subject to interrogation. An individual must be told that anything the individual says can be used against them in court. They have the right to an attorney, and if they cannot afford an attorney, one will be appointed to them prior to questioning. There is no requirement that the officer use this specific language when giving the Miranda advisement. Analyzing whether a Miranda advisement was necessary to make a finding that the defendant's statements are admissible requires the court to determine whether the defendant was in custody. This is done considering the totality of the circumstances and making a finding as to whether a reasonable person in the suspect's position would believe themselves deprived of freedom of action to the degree associated with the formal arrest. There are many factors to consider, including but not limited to the officer's demeanor and tone of voice, the persons present during the interaction, and the officer's response to questions asked by the defendant.
If the court decides the individual was in custody, the court must next determine whether an interrogation took place. An interrogation is direct questioning which is reasonably likely to elicit an incriminating response. The officer asking basic questions for gathering information for booking is not an interrogation. If the court concludes there is a Miranda violation, any statements obtained because of the violation must be suppressed.
If a defendant waives his rights pursuant to Miranda, the court must find that the waiver was made in a voluntary, knowing, and intelligent manner. The decision to waive these rights must be a free and deliberate choice. Again, there are many factors to consider in deciding whether a person has made a voluntary waiver of their Miranda rights. Some of these factors are the amount of time between the advisement and interrogation, whether the suspect or law enforcement initiated the interview, and whether the officer reminded the suspect of their rights prior to the interrogation beginning. There are a couple of issues to keep in mind when looking at the suppression of statements. If the defendant makes a statement that is not in response to questions asked by officers, the statement is deemed spontaneous and Miranda does not apply. Further, an illegal arrest does not bar the introduction of legally obtained statements. You should consider these cases based on the specific facts of the case.
In summary, suppression law and suppression hearings can be complicated. The court must have a firm understanding of the issues and the law. We hope this simple guide is helpful in getting you going in the right direction.